This is an evidentiary hearing before the Indiana Utility Regulatory Commission, and a cause docketed before the commission as cause number 37791 GCA 114, captioned as Petition of Switzerland County Natural Gas Company Incorporated for approval of changes in its gas cost adjustment in accordance with Indiana Code 8-1-2-42G. Notice of the time and place of the hearing was given as provided by law by publication in Marion County through the Indianapolis Star on June 4th, 2024, and in Switzerland County through the Vevey Reveille Enterprise on June 6th, 2024. These are newspapers of general circulation, and these publications were made at least 10 days prior to the date of the evidentiary hearing. The proofs of publication of the notices have been received by the Commission and are now incorporated into the record of this cause by reference and placed in the official files of the Commission. Notice has also been given to the Indiana Office of Utility Consumer Counselor and other interested parties. May we have appearances, please, first on behalf of petitioner.
Thank you, Your Honor. On behalf of petitioner, Switzerland County Natural Gas Co. Incorporated, please accept the appearance of Lauren Aguilar from the law firm of Barnes & Thornburg, LLP.
Thank you, Ms. Aguilar. On behalf of the public.
Thank you, Your Honor. On behalf of the public, Victor Peters of the OUCC.
Thank you, Mr. Peters. And Ms. Aguilar, before you start your case, I just want to note for the record that prior to going on the record today, I had an informal conversation with counsel, and as our plan, that petitioner will admit its exhibits, followed by the OUCC admitted exhibits out of order, and which will be followed by Ms. Mann's testimony at that point in time. So with that understanding, Ms. Aguilar, when you're ready.
Thank you, Your Honor. At this time, petitioner would move to admit what has been pre-marked as Exhibit Number 1, the direct testimony of Ms. Bonnie Mann, Exhibit Number 2, which is the petitions and schedules, Exhibit Number 3, which includes the revised schedules and the revised direct testimony of Ms. Mann, and Exhibit Number 4, which is petitioner's response to the Commission's July 3rd docket entry request.
Let's go off the record for a moment, please. Let's go back on the record. We've now had an opportunity to correct the numbering on the hard copies of Ms. Mann's direct testimony and the petition. Ms. Aguilar, is my understanding, Bonnie Mann's direct testimony with attached, is marked as petitioner's Exhibit 1, and the petition with attachments is marked as Exhibit 2. Is that correct?
That is correct. Thank you, Your Honor.
Thank you. And Mr. Peters, any objections?
Thank you, Your Honor. The public has no objections and waives cross-examination.
Public Exhibits 1, 2, 3, and 4 are admitted into the record without objection. It's my understanding the petitioner is not yet resting, but we're now going to take the OUCC's exhibits out of order. Mr. Peters, when you're ready.
Thank you, Your Honor. The public offers the following exhibits for admission onto the record. Public Exhibit Number 1, testimony of OUCC witness Lucretia N. Vox. Public Exhibit Number 2, GCA 114 factor calculations. Public Exhibit Number 3, GCA 114 statistical calculations.
Ms. Aguilar, any objections?
Your Honor.
Oh, excuse me, please continue.
Public Exhibit Number 4, petitioner's responses to OUCC data requests and Public Exhibit Number 5, OUCC Recalculation of Schedules 1, 6, and 12B.
Thank you, Mr. Peters. Ms. Aguilar?
Yes, petitioner does not have any objections to the admission of these exhibits, and prior to the hearing, we conferred and we waived cross-examination.
Public Exhibits 1, 2, 3, 4, and 5 are admitted into the record without objection. Mr. Peters, any further exhibits at this time?
Thank you, Your Honor. Nothing further.
Okay, and Ms. Aguilar?
Yes, at this time, petitioner would like to call to the stand Ms. Mann.
And Ms. Mann, before you... And Ms. Mann, before you have a seat, if you would raise... Now we're ready. All right, Ms. Mann, thank you. You have your right hand raised. Do you swear or affirm the testimony you are about to give in this cause will be the truth, the whole truth, and nothing but the truth? Thank you, Ms. Mann. If you would, please have a seat. And if you would, state your full name and spell it as well, please.
Bonnie Mann, B-O-N-N-I-E, M-A-N-N.
Ms. Aguilar, did you have any direct examination you wanted to solicit from Ms. Mann?
Sure, if that's okay. Ms. Mann, can you please explain your relationship to petitioner?
Yes, we are consultants for the petitioner. LWG CPAs and advisors are also their financial statement auditors, and we were hired to prepare the GCA schedules in this cause.
And how long have you...
A little bit closer, okay.
And how long have you worked with petitioner?
Me personally, over 30 years.
Thank you, Ms. Mann. Judge Lloyd, I believe that you may ask your questions at this time.
Thank you. Ms. Mann, are you timely receiving information from petitioner such that you can adequately prepare schedules?
Yes.
Is that information or that data that you're receiving, is it faulty? Is it accurate in relationship to the schedules that were first filed in this cause?
It was accurate, except for the incorrect GCA factor that was charged in 1 month of the GCA. We weren't provided that information.
Okay. And the errors that were in your first set of schedules, were those errors due to petitioner's data?
No, they were errors. They were human errors made in inputting all of those numbers into complex set of Excel schedules.
And the changes that you made to the first set of schedules, was that due to information you received from petitioner after those first set of schedules were filed?
With the exception of the question about the GCA factor, no.
You discussed, petitioner discussed that 2 individuals are involved in the preparation of schedules before they are pre-filed with the commission. Are there additional safeguards in place to ensure that schedules are, when schedules are submitted, those schedules are accurate?
We have a preparer who does a self-review, and then we have a reviewer who does a final review.
And what is your role in that process?
I do a summary review for reasonableness, and I am responsible for preparing the testimony. Ultimately, though, I'm responsible.
And so petitioner stated in its July 10th, 2024 docket entry response that your firm, quote, commits to keep only those individuals who are very familiar with petitioner's processes as the working individuals on petitioner's matters for the foreseeable future to help ensure accuracy of future submissions, close quote. Does this plan of action involve a change in the individuals who prepared the first set of schedules in this cause?
At this time, it does not. We believe that when you change personnel, you actually make it more difficult to be accurate because you don't understand the processes. You don't understand. All these GCAs are the same, and every single one of them is different. And so by changing personnel, we have to retrain from the beginning on the utilities processes. If we leave the people who are on there now and simply work with them to improve their performance, we believe that we will get a better result or a more quick correction.
And so as you look back to the preparation of the first set of schedules, and the second set for that matter, what do you identify specifically as being the cause of those errors?
Again, it's human error. There's a lot of numbers. It's much more complicated than it seems. If you make a small error on Schedule 8, 9 schedules in that GCA have changed. And understanding every single one of those schedules and how they change is something that is challenging to learn when you only do something 4 times a year.
And so the docket entry question that went unanswered is what changes will be instituted to help ensure the accuracy of future submissions?
Well, when we have a situation like this where we didn't live up to our own expectations, we always are going to have internal discussions, internal questions about need for remedial training, about need for additional assistance. But that's not different than we would do sort of after any project that had any kind of difference in it. So that's part of our regular process. So that's not an additional step we're taking. It's a step we already take. But we believe that having those, and like I said, this is July. In August, we have annual GCA review training so that everybody who works on GCAs can talk about what the issues are, what they've found that makes things work better for them, where we're seeing challenges so that we can make improvements. We do work with more than one utility. So all of those people are getting together and talking about the issues so that we can improve the process overall.
And so if I understand correctly, and correct me if I'm wrong, after your firm has internal discussions amongst the team to identify, okay, what happened here? Why did we make these mistakes? And then you have conversations to specifically address whatever caused those shortcomings. Is that right?
Yes.
Did you has your firm had those conversations regarding the schedules at issue in this cause?
No, unfortunately, I have been ill, and I have not been in the office to address those conversations, but yes, they are forthcoming.
When was the last time that Switzerland County submitted schedules in this series of GCA trackers that did not require a revision?
I can't tell you that off the top of my head. I work with multiple utilities and multiple GCAs, and most of them get refiled for something. Sometimes it's small, sometimes it doesn't even affect the GCA factors, but I don't have a tally in my head.
In light of, when do you believe Switzerland County would submit its next GCA request?
End of August.
End
of August.
Would that be before or after your upcoming training?
After. We have several GCA, several utilities with GCAs that file in by the end of August, which is why we hold the training in August, so that it's fresh in everybody's mind as we do that round of GCAs.
So prior to that submission, you will have had I'll call it a debriefing conversation with the team and have undergone this training. Is that correct?
Yes.
is it a reasonable expectation that Switzerland County's first set of schedules to be submitted with the upcoming cause will be submitted accurately?
That is always our intention.
Is that a reasonable expectation?
I think so, but again, that's always our intention. We're not intentionally filing incorrect schedules. We're always intending to file correct schedules.
All right, I don't have any further questions. I know typically the commission does not allow follow-up questioning on bench questions, but Ms. Aguilar, I wanted to give you the opportunity to do so if you so desired.
Sure. Ms. Mann, you expressed that you do not intentionally, intend to file incorrect schedules. Can you just please explain to the commission, how you feel about the incorrect schedules that were filed in this particular GCA?
Obviously, it's never acceptable to have these errors. That's why we have the debriefings, to talk about what we're missing and to find ways to improve it. Sometimes the issues are easy to solve, sometimes the issues are harder to solve, but we are always working to improve the process.
Thank you, Ms. Mann. Nothing further.
Mr. Peters, any questions?
No, Your Honor.
All right, thank you, Ms. Mann. You are excused from the witness stand. Ms. Aguilar, when you're ready.
At this point, petitioner rests.
Thank you. Mr. Peters.
Public rest. Thank you, Your Honor.
Based on an informal conversation I had with counsel before going on the record, it's my understanding petitioner intends to submit its proposed order by close of business on this coming Friday. Is that correct, Ms. Aguilar?
That is correct. I would say Monday at the very latest, but it would be expeditiously, not the end of the day. But Friday is our intention.
So what's our firm deadline?
I would say firm deadline would be Monday by noon, but with the intention on beating that deadline.
Very well. In that case, the petition is taken under advisement and this hearing is adjourned. Thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor.